Part 2 of Fundamental Rights and Fundamental Duties of our Constitution. The powers of the judiciary vis-a-vis the legislature are weaker in India than in the United States in two respects. Firstly, fundamental rights under Indian Constitution distinguished from American Bill of Rights. Firstly, while the declaration of the American Bill of Rights are absolute and the power of the state to impose restrictions upon the fundamental rights of the individual in the collective interests had to be evolved by the judiciary. In India, this power has been expressly conferred upon the legislatures by the Constitution itself in the case of the major fundamental rights, of course, leaving a power of judicial review in the hands of the judiciary to determine the reasonableness of the restrictions imposed by the legislature. 44th Amendment 1978, the right to property. Secondly, by somewhat hasty step, the Janata government headed by Morarji Desai had taken out an important fundamental right, namely the right of property, by omitting Article 19(1)(f) and 31 by the 44th Amendment Act 1978. Of course, the provision in the same amendment being transposed to a new article 300A, which is outside part 3 of the Constitution and has been labeled at chapter 4 of part 12, which deals with finance, property, contracts and suits. But this is not a fundamental right. While under the Congress rule for 30 years, the ambit of fundamental rights embodied in part 3 of the original Constitution had been circumscribed by multiple amendments. Bit by bit, the death blow to one of the fundamental rights came from the Janata government. The net result of the foregoing amendments inflicted upon the right to property are the right not to be deprived of one's property save by authority of law is no longer a fundamental right. Hence, if anybody's property is taken away by exhaustive fiat without the authority of law or in contravention of a law, the aggrieved individual shall have no right to move the Supreme Court under Article 32. If a legislature makes a law depriving a person of his property, he cannot challenge the reasonableness of the restriction imposed by such law, invoking Article 19(1)(f), because that provision has ceased to exist. Since Clause 2 of Article 31 has vanished, the individual's right to property is no longer a guarantee against the legislature in respect of any compensation for loss of such property. Article 31(2) in the original Constitution embodied the principle that if the state makes a compulsory acquisition or requisitioning of private property, it must make a law. B, such law must be for the public purpose, and C, some compensation must be paid to the expropriated owner. Of course, by the 25th Amendment of 1971, during the regime of Mrs. Gandhi, the requirement of compensation was replaced by an amount, the adequacy of which could no longer be challenged before the courts. Nevertheless, the Supreme Court held the aggrieved individual might complain if the amount so offered was illusory or amounted to confiscation, but even such an innocuous possibility has been foreclosed by the 44th Amendment. The short argument advanced in the statements of objects and reasons of the 45th Amendment will for deleting the fundamental right to property is that it was only being converted into a legal right. What is meant is that while Article 19(1)(f) and 31(2) of the original Constitution operated as limitations on the legislature itself, the 5th Amendment will installs the legislature as a guardian of the individual's right to property without any fetter on its goodwill and wisdom. But if the legislature could be presumed to be infallible and innocent, this would be a good argument for omitting all the fundamental rights from Part 3. As it has been pointed out earlier, the very justification of putting limitations on the legislature by adopting a guarantee of fundamental rights is that history has proved that the group of human beings constituting for the time being the majority in a legislative body are not always infallible, and that is why the constitutional safeguards are necessary to permanently protect the individual from legislative tyranny. Thirdly, by subsequent amendments, the arena of fundamental rights has been narrowed down by introducing certain exceptions to the operation of fundamental rights, namely Article 31A, 31B, 31C, and 31D. Of these articles, 31A, 31C are exceptions to the fundamental rights enumerated in Article 14 and 19. This means that any law falling under the ambit of Article 31A, as for example, a law for agrarian reform, or Article 31C, a law for the implementation of any of the directive principles contained in Part 4 of the Constitution, cannot be invalidated by any court on the ground that it contravenes any of the fundamental rights guaranteed by Article 14, equality before law, Article 19, freedom of expression, assembly, etc. Article 31B, however, offers almost complete exception to all the fundamental rights enumerated in Part 3 if any enactment is included in 9th schedule, which is to be read along with Article 31B, then such enactment shall be immune from constitutional invalidity on the ground of contravention of any of the fundamental rights, but shall be open to challenge on the ground of damage to the basic structure of the Constitution subsequent to 24/4/1973, that is the date of decision of Keshavanand's case. Fourthly, by the 42nd Amendment Act 1976, a contravening factor has been introduced, namely the fundamental duties mentioned in Article 51A, though these duties are not themselves enforceable in the courts nor their violation as such punishable. Nevertheless, if a court before which a fundamental right is sought to be enforced has to read all parts of the Constitution, it may refuse to enforce a fundamental right at the instance of an individual who has patently violated any of the duties specified in Article 51A. If so, the emphasis of the original Constitution on fundamental rights has been minimized. Fifthly, the correct category of the fundamental rights under our Constitution is exhaustively enumerated in Part 3 of the Constitution, and American Constitution 9th Amendment expressly says that the enumeration of certain rights in the Bill of Rights shall not be construed to deny or disparage other retained by the people. This rests on the theory of inalienable natural rights, which can by no means be lost to the individual in a free society. The guarantee of some of them in the written Constitution cannot therefore render obsolete any right which inhered in the individual even before the Constitution, as for example the right to engage engage in political activity, but there is no such unenumerated right under our constitution. As was observed in the early case of Gopalan versus state of Maharashtra, the legislatures under our constitution being sovereign except insofar as their sovereignty has been limited by the constitution, either expressly or by necessary implication. The courts cannot impose any limitation upon the sovereignty either on the theory of the spirit of constitution or of that of natural rights, that is, rights other than those which are enumerated in part 3 of the constitution. Any expansion of the fundamental rights under the Indian constitution must therefore rest on judicial interpretation, and the Supreme Court has gone ahead in this direction by enlarging the scope of Article 21. It should not be supposed, however, that there is no other justiciable right provided by our constitution outside part 3. Limitations upon the state are imposed by other provisions of the constitution, and these limitations give rise to corresponding rights to the individual to enforce them in a court of law if the executive or the legislature violates any of them. Thus Article 265 says that no tax shall be levied or collected except by the authority of law. This provision confers a right upon an individual not to be subjected to arbitrary taxation by the executive, and if the executive seeks to levy a tax without legislative sanction, the aggrieved individual may have his remedy from the courts. The new provision in Article 300A belongs to this category. Similarly, Article 301 says that subject to the provisions of this part, trade, commerce and intercourse throughout the territory of India shall be free. If the legislature or the executive imposes any restriction upon the freedom of trade or intercourse which is not justified by the other provisions of Part 13 of the Constitution, the individual who is affected by such restriction may challenge the action by appropriate legal proceeding. When then is the distinction between the fundamental rights included in Part 3 of the Constitution and those rights arising out of the limitations contained in the other parts which are equally justiciable? Though the rights of both these classes are equally justiciable, the constitutional remedy by the way of an application direct to the Supreme Court under the Article 32, which is itself included in Part 3 as a fundamental right, is available only in the case of fundamental rights. If the right follows from some other provisions of the Constitution, say Article 265 or Article 301, the aggrieved person may have his relief by an ordinary suit or by an application under Article 226 to the High Court, but an application under Article 32 shall not lie unless the invasion of the non-fundamental right invokes the violation of some fundamental rights as well. As the word fundamental suggests, under some constitution, fundamental rights are immune from constitutional amendments. In other words, they are conferred a special sanctity as compared with other provisions of the Constitution. But this principle has been rejected by the Indian Constitution as it stands interpreted by amendments of the Constitution themselves and judicial decisions. Of course, no part of the Constitution of India can be changed by ordinary legislation unless so authorized by the Constitution itself, as for example Article 4. But all parts of the Constitution except the basic feature can be amended by the Amendment Act passed under Article 368, including the fundamental rights. This proposition has been established after a history of its own. Until the case of Golaknath, The Supreme Court has been holding that no part of our constitution was unamendable and that Parliament might, by passing a Constitution Amendment Act in accordance with the requirements of Article 368, amend any provision of the Constitution, including the fundamental rights and Article 368 itself. According to this earlier view, thus the court could act as a guardian of the fundamental rights only so long as they were not amended by the Parliament of India by the required majority of the votes. In fact, some of the amendments of the Constitution so far made were effected with a view to suppress superseding judicial pronouncements which had invalidated social or economic legislation on the ground of contravention of fundamental rights. Thus, the narrow interpretation of Clause 2 of Article 19 by the Supreme Court in the cases of Ramesh Thapar versus State of Madras and Brijbhushan versus State of Delhi was superseded by the Constitution First Amendment Act 1951, while the interpretation given to Article 31 in the cases of State of West Bengal versus Gopal, Dwarika Das versus Solapur Spinning Company and State of West Bengal versus Bela Banerjee was superseded by the Constitution Fourth Amendment Act 1955. But the Supreme Court cried halt to the process of amending the fundamental rights through the amending procedure laid down in Article 368 of the Constitution by its much debated decision in Golaknath versus State of Punjab. In this case, overruling its two earlier decisions, the Supreme Court held the fundamental rights embodied in Part 3 has been given a transcendental position by the Constitution, so that no authority functioning under the Constitution, including Parliament exercising the amending power under Article 368, was competent to amend the fundamental rights. C. But by the 24th Amendment Act 1971, Article 13 and Article 68 were amended to make it clear that fundamental rights were amendable under the procedure laid down in Article 368, thus overriding the majority decision of the Supreme Court in Golaknath versus State of Punjab. The majority decision in Keshavanand Bharati case upheld the validity of these amendments and also overruled Golaknath's case, holding that it is competent for Parliament to amend fundamental rights under Article 368, which does not make any exception in favor of the fundamental rights, nor does 13 comprehend acts amending the Constitution itself. At the same time, Keshavananda's case also laid down that there were implied limitations on the power to amend, and that power cannot be used to alter the basic feature of the Constitution. A big limitation that stands in the way of Parliament acting by a special majority to introduce drastic changes in the Constitution is the judicially innovated doctrine of basic features, which can be eliminated only if a bench larger than the 13-judge bench in Keshavanand's case be prepared to overturn the decision in that case. In the meantime, applying Keshavanand's, the majority of the Constitution bench has invalidated Clause 4 and 5 of Article 368 as violative of the basic features of the Constitution. Minervaville versus Union of India, 1980 Supreme Court 1789, para 21 and 28. The provisions of Part 3 of our Constitution, which enumerate the fundamental rights, are more elaborate than those of any other existing written constitution relating to fundamental rights and cover a wide range of topics. The Constitution itself classifies the fundamental rights under 7 groups as follows: right to equality, right to particular particular freedoms: right against exploitation, right to freedom of relation, cultural and educational rights, right to property, right to constitutional remedies. Of these, the right to property has been eliminated by 44th Amendment Act, so that only 6 freedoms now remain in Article 19(1). The rights falling under each of the 6 categories are shown in the table 5. Another classification which is obvious is from the point of view of persons to whom they are available. Thus, some of the fundamental rights are granted only to citizens. First, protection from discrimination on ground only of religion, race, caste, sex, or place of birth. Article 15. Equality of opportunity in matters of public employment. Article 16. Freedoms of speech, assembly, association, movement, residence, and profession. Article 19. Cultural and educational rights of minorities. Article 30. Some of the fundamental rights, on the other hand, are available to any person on the soil of India, citizen or foreigner. Equality before the law and equal protection of the law. Article 14. Protection in respect of conviction against ex post facto laws, double punishment and self-incrimination. Article 20. Protection of life and personal liberty against action without authority of law. Article 21. Right against exploitation. Article 23. Freedom of relation. Article 25. Freedom as to payment of taxes for the promotion of any particular religion. Article 27. Freedom as taxes for the freedom as to attendance at religious instruction or worship in state educational institution. Article 28. Some of the fundamental rights are negatively worded as prohibition to the state, as for example, Article 14 says, the state shall not deny to any person equality before the law. Similar are the provisions of Article 15(1), 16(2), 18(1), 20, 22(1), 28(1). There are others which positively confer some benefits upon the individual, as for example the right to religious freedom under Article 25 and the cultural and educational rights under Article 29(1), 31. Still another classification may be made from the standpoint of the extent of limitation imposed by the different fundamental rights upon legislative power. On the one hand, we have some fundamental rights such as under Article 21 which are addressed against the executive but impose no limitation upon the legislature at all. Thus, Article 21 simply says that no person shall be deprived of his life or personal liberty except according to the procedure established by law. It was early held by our Supreme Court that a competent legislature is entitled to lay down any procedure for the deprivation of personal liberty, and that the courts cannot interfere with such law on the ground that it is unjust, unfair, and unreasonable. In this view, the object of Article 21 is not to impose any limitation upon the legislative power, but only to ensure that the executive does not take away a man's liberty except under the authority of a valid law, and in strict conformity with the procedure laid down by such law. In later case, however, the Supreme Court has found it difficult to immunize laws made under Article 21 from the attack on the ground of unreasonableness under the relevant clauses of Article 19(1) or Article 14, and recent Supreme Court decisions show an increasing inclination in that direction. To the other extreme are fundamental rights which are intended as absolute limitations upon the legislative power, so that it is not open to the legislature to regulate the exercise of such rights, as for example the rights guaranteed by Article 15, 17, 18, 20, 24. In between In between the two classes stand the rights guaranteed by Article 19, which itself empowers the legislature to impose reasonable restrictions upon the exercise of these rights in the public interest. Though the individual rights guaranteed by Article 19 are in general binding upon both the executive and the legislature, these authorities are permitted by the Constitution to make valid exceptions to the rights within limits imposed by the Constitution. Such grounds, in brief, are security of the state, public order, public morality, and the like. All the above rights are available against the state. It is now settled that the rights which are guaranteed by Article 19 and 21 are guaranteed against state action as distinguished from violation of such rights by private individuals. In the case of violation of such rights by individuals, the ordinary legal remedies may be available but not the constitutional remedies. This is all about today's part of fundamental rights and fundamental duties. Thanks, regards.